Thank you, Maria, for that introduction. Um, I've been asked today to speak on the subject of commercial courts and the establishment of a system of commercial courts in the province of Sindh. Honorable Mr. Justice Mushir Alam has already spoken very passionately on this subject and made a very clear call for a system of commercial courts to be established in Sindh. Justice Jawad Hassan has taken the lead on this score in Lahore, and due to the efforts of the Lahore High Court, a system has already been established by virtue of an ordinance promulgated in Punjab. But to understand the background as to how commercial cases have historically been dealt with in Sindh, it's necessary to illumine you on a specific and very unique jurisdiction which the Sindh High Court enjoys. That is a original civil jurisdiction which is very different from that which vests in any other high court. It is a unique jurisdiction vested exclusively at the moment in the Sindh High Court. Perhaps the Islamabad High Court enjoyed a similar jurisdiction at some point in time, but I think that experiment was jettisoned after a brief trial. Perhaps Justice Babar Sattar will be able to share the reasons for that in due course. But this original jurisdiction of the Sindh High Court dates back to the Sindh Courts Act of 1926, and it now exists by virtue of the Sindh Civil Courts Ordinance of 1962. And under the relevant section of that ordinance, any civil suits and proceedings over a particular pecuniary threshold originate in the High Court as opposed to the court of the district judge, which is the system otherwise prevalent all across the length and breadth of the country. As far as the way in which such cases are to be dealt with at the level of the High Court, the Chief Court rules already provide for a classification of what constitutes a commercial cause, and those commercial causes are meant to be accorded priority. But in practical effect, the way in which the jurisdiction is designed, and I had prepared certain slides. Perhaps if the first slide can be put up showing the wording of the section, which is section 7 of the Sindh Civil Courts Ordinance, that will give you some idea of the structure. That basically does not classify any subject matter. It simply says that any civil suits or proceedings at present valued at over 65 million rupees will originate in the High Court. Now, as and when the Civil Courts Ordinance was promulgated in 1962, this value was perhaps initially set at a much lower threshold of 25,000 rupees. It has been enhanced from time to time, from 5 to 5 lakhs, then to 30 lakhs, to 1.5 crore. But what we have seen, and now if we can have the slide showing the relevant data, the figures show that as and when the jurisdiction has been enhanced, the level of pendency still continues to rise unabated. More often than not, except on barring one occasion, the cases that have then fallen short of that threshold have also not been sent down to the district judiciary. They've been retained in the High Court. So at present, we have now perhaps a little over 21,000 civil suits and proceedings in the High Court, whereas the entire district judiciary in the District of Karachi, comprising perhaps 63 or 64 courts of senior civil judges, has a lower pendency of about 16 to 17,000 civil suits. A division bench of the Sindh High Court recently had opportunity to address this issue in certain petitions which had been filed challenging this original jurisdiction. And I was a member of that bench along with our Chief Justice, and I had the good fortune of being able to author a judgment on this. And building on what has been done in Punjab under the auspices of the Lahore High Court, we had recommended to the provincial government that legislation is required to correct this issue, to bring about meaningful reform, whereby the jurisdiction of the High Court was restructured. We had asked them to consider setting up a system of commercial courts in the province. As I was saying, the directions that were issued to the provincial government in that case were essentially to consider necessary measures to be placed before the legislature for legislative amendments to be brought about to the Civil Courts Ordinance to restructure the jurisdiction of the High Court. Because historically, we have always been told that the Sindh High Court was conferred this extraordinary jurisdiction because of the fact that Karachi was a port city, it was a hub of commerce, of economic activity, that complex cases would, come up where intricate points of law would be involved, requiring deliberation by a high court judge. Those cases could perhaps not be left up to a senior civil judge to decide. And even if that is so, even if we were to accept that argument, the way in which the jurisdiction has been structured to date have yielded a result where the vast corpus of cases which are now before the High Court are of a purely non-commercial nature. The vast corpus of cases are those dealing with the subject of administration, of specific performance, disputes in relation to land, none of which, properly speaking, have a real commercial element involved. So we had given a suggestion that if this jurisdiction, in view of its historic importance, is to be retained, that if this jurisdiction, in view of its historic importance, is to be retained, then perhaps it could be considered restructuring it along the lines of a purely commercial court, of restructuring it not simply on the basis of a pecuniary threshold, but also on the basis of subject matter, where you come up with a rational definition of what constitutes a commercial dispute, what constitutes a commercial case, and then applying a pecuniary threshold along with that so as to create one tier of a court within the High Court itself. And in tandem with that, you could also create a network of commercial courts across the province, in such such locations as the need arises, along the lines of what has been done in Punjab. The Board of Investment have also gotten involved in this exercise, and we are told that perhaps a draft bill has been, drafted, but to date, no meaningful steps have been taken as yet by the provincial government for reasons that are best known to them. And unfortunately, that is where the matter rests at this point.
Thank you, Mr. Justice Sayeed. I would just like to take the opportunity to ask you about the judgment that we talked about, the judgment of Pafan and Partners. I have to say I found it to be a very, to start off with, it was a very impressive judgment. But secondly, I found it to be very bold in that you were effectively saying that something needs to be done about this very soon. You made reference in the judgment to what you referred to as speedy justice. What did you mean by that?
Well, the way the backlog of cases is built up in the High Court, it effectively precludes us from dealing with that backlog in any meaningful way. That's the point that I was seeking to emphasize, because now if the sanction strength of the High Court is considered, at best, at any point in time, you could have a maximum of 40 judges, out of which you could perhaps at best allocate 5 or 6 to what we term the original side, where these civil suits and proceedings come up. And now with 20,000+ suits and proceedings pending, there is actually no proper way for that backlog to be tackled. And what I was trying to emphasize, or more correctly put, what the bench was trying to emphasize, is that yes, cases are meant to be disposed of in an expeditious manner within a short or at least a reasonable time frame. That doesn't mean that we hurry through proceedings, because especially cases of a commercial nature, if they do come up, then they require time, they require attention, they require proper deliberation, and you can't rush through these matters simply for the sake of disposal and clearing the backlog. That would in fact result in an injustice or a miscarriage of justice more often than not. And what we are trying to emphasize is that the High Court should actually be allowed to focus on those areas which are of its concern and which require its attention, rather than requiring it to devote its time and energy to attending to all species of litigation simply because those who have brought that cause before the court have cared to value it or overvalue it in a particular way, simply to forum shop or bring their case within the domain of that forum.
Thank you. And you've sent that message, that bold message in the judgment which has been handed down. But I'm interested to know what actually happens next in terms of trying to get people to make change. Sorry, forgive me. I was just saying, obviously, you've made that very bold judgment in the case of Pafan. And what I'm interested to know is what happens next in terms of trying to get those changes made.
Well, the case was decided only as recently as February, towards the end of February. So I think it's too early to perhaps make a judgment call and say that nothing will happen on the back of this judgment. I think sufficient time is yet to pass. We have to see what steps the provincial government takes. As I said, whatever few inquiries we've made, it appears to suggest that the matter is under consideration. We are told that discussions are ongoing, perhaps with the bar associations, to get clarity on their point of view, and that eventually the provincial government remains committed to driving this forward as a meaningful endeavor. To what extent that comes to pass, it's difficult to say. One would hope that the government would recognize that it is, at the end of the day, the obligation of the state to ensure the effective dispensation of justice. That is their constitutional role, and one can hope that they play their part. One thing which is of interest is that when we were conducting this case, all the bar associations put forward their view. They were all in favor of this measure, and one can hope that they would also play their due role in seeking to advance this cause. At the end of the day, the main stakeholders in any system are the litigants. One has to always keep that in mind, that their interests are paramount. And, the structure of the system, the way it is, their interests are the ones are what are being most adversely impacted because of the delays that are arising. And I think that's something which definitely needs to be looked into, and one would hope that action will be taken sooner rather than later.